anticipate that we will be seeing the judge.
Oh, okay.
All right.
Okay.
Morning, Asher.
Morning, Steve.
Okay, good morning, everyone. Welcome to Collier County Court. I'm Judge Martin. We've got a matter for non-jury trial today, CMR Construction and Roofing, Sean Seffer, Cheyenne Seffer versus Mark Payung. Can I get counsel's appearance for the plaintiff, please?
Morning, Judge. Asher Knipe on behalf of the plaintiffs CMR Construction & Roofing LLC, Sean Sheffer and Cheyenne Sheffer.
Okay, Mr. Knipe. And for defendant counter plaintiff?
Your Honor, Steve Blunt on behalf of Mark Payung.
Okay. All right. And Mr. Knipe, is plaintiff ready to proceed?
Yes, Judge. But before we get started, I just wanted to do some housekeeping. Mr. Blunt and I were up early this morning talking to one another on the phone to try to see if there were some things that we could do to attempt to streamline this process today.
Thank you for that.
Yeah, of course. And this goes back a couple of weeks ago. We had done a little meet and mark as was required by the court. And we have essentially stipulated to the admissibility of all exhibits with the exception of plaintiff's exhibit number 74. Mr. Blunt has objected to the audio portion of that, which is it's a video. He's objected to the audio portion of that. I'll allow Mr. Blunt to explain his objection to that. And I think that it may be something that, since this is a non-jury trial, we can just resolve that when the video gets presented to you and you can make an evaluation about whether or not the audio portion should be admitted or not. So as opposed to going through the technicalities of admitting exhibits during the course of the trial, we basically would stipulate to their admission at this point of all exhibits with the caveat that I just explained to you.
Okay.
Further, with regard to, since both parties have affirmative claims in this matter, we don't want to turn this into a procedural rodeo. I'm going to put on our case. I have 4 witnesses that I anticipate that will be testifying. I am happy to give Mr. Blunt latitude with regard to his cross-examination of those people. With regard to scope, so that he doesn't have to, turn around and recall those witnesses in his case in chief. I think that's a pointless procedural thing. I don't see any need in doing that. Mr. Blunt has graciously offered me the same type of latitude with regard to the cross-examination of his witnesses. What I anticipate doing is calling the plaintiff's witnesses, basically turning the case over to Mr. Blunt for him to call his witnesses, and then he can make his case and I will cross-examine them in the, as I see fit, with latitude given to me reciprocally. With that understanding, I imagine Mr. Blunt's on the same page as I am with that, but I'll let him state that for the record.
Okay, Mr. Blunt.
Your Honor, I'd say all that is completely accurate. I suppose formally, though, we should move into evidence. CMR's or the plaintiff's exhibits 1 through 80 as identified on their amended exhibit list, which would omit those that they withdrew on the amended exhibit list. Matters not, though, because the ones that he withdrew are within my exhibits anyway. And then move into evidence the Payung exhibits 1 through 25, if we can just consider those all admitted as of the beginning of the trial, it'll make things a lot faster. And then again, also, wide latitude on cross for both sides so that he doesn't have to call Mr. Payung during his case in chief, and I won't have to hopefully recall his witnesses during my case in chief, although I suppose it is possible that something might pop up and I'll want to recall one of them for short reason. But if I'm given wide latitude on cross, I'm hoping we can avoid that.
All right. And I know I've got the clerk on. Did you all provide hard copies of all these things to the clerk?
I don't know the answer to that specifically. I know that there were hard copies that went out. I imagine, actually, I don't know if they were hard copies or electronic copies, but I do know that these things were submitted to the clerk. I think both sides have submitted these to the clerk, but I would allow the clerk to correct me about that if I'm mistaken.
Let me check in with Clerk Lawson. Do you have, it was just referenced, and perhaps you could give me a date, Mr. Blunt, plaintiffs exhibits 1 through 80 per the amended exhibit list that was filed when? Which list are we looking at there?
I'm pulling it up now, Your Honor. Their amended exhibit list. Oh, the one he gave me was not dated. 1 second.
I have a March 26. That does not say amended.
It's and for your purposes, Judge, there were no new exhibits. So, to the extent there was an amendment, there were no new exhibits on there.
It was to narrow the list, I think.
Catherine.
Yes.
Okay. Let's see, everything I'm looking at looks like it's Mr. Blunt's witness lists.
Let me see if I can get
My exhibit list, Your Honor, was filed on May 28th. We provided your judicial assistant, Your Honor, the electronically an amended exhibit list on Friday because we realized that I'd had a pretrial conference with Mr. Knipe, and he had asked me to include some additional pages for completeness, and we failed to do that on the first one. So we amended and sent you the amended exhibit list, or sent your JA the amended exhibit list on Friday via an electronic link. And Catherine, did we physically file the exhibits with the clerk? Yes. And when that was on Friday as well? We physically filed ours on Friday, Your Honor.
Now, Mr. Blunt, I'm looking at yours from Friday. It looks like 1 through 28. I think a minute ago you said 1 through 25. I think 26, 27, 28 maybe are just generic. They're not actual exhibits.
Okay. Judge, I'm speaking to my assistant on the phone right now, and what I'm being told is that somebody spoke to your judicial assistant and that we submitted them to your judicial assistant, but that we weren't going to be submitting them to the clerk. So
I have digital copies, basically a share file from you and a Dropbox from Mr. Blunt. But let me check in with the clerk. Madam Clerk, have you been given exhibits so that you can manage this for us?
Good morning, Judge. No, ma'am, I do not have any exhibits.
Okay. And if I simply forward you the Dropbox links and things like that, that's not actually going to be very helpful, is it?
No, ma'am.
So I'm trying to go back, guys, and remember because I've got a lot of trials set, so I might be mixing up my conversations, but my usual spiel is to tell the lawyers I'm fine with a Dropbox link, but the clerk has to have a hard copy of everything. And I know you all were going to work to stipulate, and I appreciate that you did, but she's actually got to have copies of all of that. So the good news, Madam Clerk, is that they agree to all of it. So I think it's not like you've got to sort and deal with a lot of things that are not coming in and so forth. Perhaps we can arrange that by the end. I mean, I think we can proceed with the trial.
Okay.
And it may just be that I don't have much I can ask Madam Clerk to do for us. And maybe we just have you all courier down there by the end of the day, a hard copy of all that. The fact that it's being admitted en masse helps significantly. So,
and Your Honor, as a point of clarification, and boy, you threw me with the exhibits 1 through 28. 26, 27, and 8 are the classic any and all exhibits listed by the other party, any and all exhibits necessary for rebuttal, etc. There are, in fact, only 25 exhibits that we're moving into evidence.
All right, good. So that's the May 28 defendant list. Did we ever figure out what was the controlling plaintiff list, what the date of that was?
Copy of all the exhibits, our exhibits to the clerk today. Yes. Yeah, my office will have a hard copy of all the exhibits delivered today, Judge.
Okay. All right. I know we're all paperless, but the clerk's office, with regard to the exhibits, in terms of making a proper record, does still require those, and I understand why. So, did anybody ever figure out what the date is of the controlling plaintiff's exhibit list, which shows that 1 through 80 that I'm going to be looking at?
Let me, if I may here, Judge.
This is so I can orient the clerk to what we're going to be talking about, since she doesn't actually have the documents yet.
We filed our exhibit list. The operative one.
I show it by email on May 25th, Your Honor.
Okay, thank you. Judge, we'll go with March 20. My assistant says March 26th. So.
Okay, that's what I'm seeing too as the most recent from your side. It's not actually denoted as an amended.
And candidly, that Judge, that's fine. I mean, for our purposes, I will, to make everyone feel a little bit better. I don't intend on going through all 80 exhibits today, candidly. There's probably like, I don't know, maybe 15 or so exhibits that I'm going to be going through. So, I mean, all these things will be delivered to the clerk's office, but for the trial purposes, even though they were admitted, I'm not going to be going through all of them.
Okay. And likewise, this lists 1 through 88. It looks like 84 to 88 are generic, but it looks like there are 83 potentially.
Right. There was a the last two or three. There is and I think that if you looked at the Mr. Blunt's filing with regard to our meet and mark, there were some that were withdrawn at that point because they were either, we discussed them and they were either irrelevant or, it just didn't matter. So it's just the 1 through 80, which the 80th one is if I may here, I think I'm bringing the exhibit list up in front of me here. The 80th one is photos of on-it Home Depot receipt, et cetera, that would be the last exhibit that we would be admitting.
Okay. All right. And so that's what will be delivered to the clerk's office, 1 through 80. And again, by stipulation, all are being admitted. But we have argument to be had about the audio portion of Exhibit 74.
Yes, ma'am.
And then for Mr. Blunt, 1 through 25, all are to be admitted without exception.
Yes, ma'am.
All right. And so for the record, I will grant that stipulated motion and will admit all of those as noted. And both parties are free to discuss the contents of all of those exhibits. And we will hold until it becomes relevant the argument as to the audio portion of number 74 by plaintiff. So the clerk can help us by making that record. We'll get all of that to Madam Clerk. Madam Clerk, anything else that you would ask or suggest at this point, and it may be that I go ahead and release you. What do you think, since you don't have the hard copies and they're all coming and they're being admitted en masse, what are you thinking at this point?
May I ask, Judge, that the attorneys drop the exhibits off on the 4th floor, the criminal department? That way I know that I'll receive them. It kind of goes through a process from the 1st floor to the 4th floor, but if they can come directly to the 4th floor, that would be helpful.
Okay, drop to the 4th floor. Attention, Clerk Lawson.
Yes, ma'am. Thank you.
All right.
We'll do it, Your Honor.
And Madam Clerk, I guess I'm just trying to shadow box you. I've been sort of doing your job on the smaller hearings. We probably still can make good use of your time because you'll make the trial notes, track the witnesses, and all of those things,
Yes,
even though you're
ma'am.
not managing exhibits. Okay, I didn't want to waste your time, but I am, as I'm thinking out loud, there are still a number of other things that you can do to support the trial. Is there anything else that you would ask of us to make sure you've got what you need?
No, ma'am. Thank you very much.
Okay, well, don't hesitate to break in. And let me ask, do I have among us, do we have a court reporter?
No.
Okay, all right, so we're not working with a court reporter. So everyone here is either attorney, party, or witness, other than Madam Clerk. But Madam Clerk, you know my style. Don't be shy if you need a break or if we've done something to throw off what you're trying to do. Please, please, please chime in and interrupt. I don't know how much Zoom you're doing, Madam Clerk. I've been in my own little world over here, but you know, there's a cool little thing where you can raise your hand if you don't want to interrupt. I'll keep a close eye and just make sure if anybody else needs to do that.
Thank you.
Thank you. All right, and then let me start with Mr. Knipe. Anything else from a pretrial standpoint that plaintiff needs to raise? And then I'll ask the same question of Mr. Blunt.
I don't have anything I'm going to be raising at this point in time.
Anything else, Mr. Blunt, housekeeping or pretrial issues?
The only other pretrial issue, Your Honor, is I suppose it would be wise for us to invoke the rule and instruct the witnesses not to watch the YouTube channel of the other witnesses during their testimony. Obviously, Mr. Payung will stay in the room. Cheyenne Sheffer, I assume, will stay in the room. And Mr. I'm not sure how to pronounce Mr. Is it Soule or Soule?
Soule.
Soule. Mr. Soule, obviously, I assume is the corporate representative for CMR, so he can stay in the room. But I think Ms. Marvel, Ms. Downing, and Ms. Reese Payung should probably step out during the testimony of the other witnesses.
All right. Any response to that, Mr. Knipe?
I'm just not sure how this works on Zoom, to be honest with you.
You just better have their cell phones to call them up and get them on deck when it's time to call them.
Right. Do you put them into a breakout room, or is that how it works?
I can just return them to the waiting room, and you know, I don't know how quickly things will go. Tech being what it is, if you all, if those of you who are going to be put into the waiting room want to drop off, as long as counsel can text you, you can hop on pretty instantly. I'm comfortable with that if counsel is, but the easiest is just to have them go to the waiting room. And again, each of you would be admonished and asked to pledge that you will not be communicating with each other, and also not logging on to try to watch the stream. Our courtrooms are being kept public, even though this is being done by Zoom, so there is a public access to what we're doing here, but you all will be forbidden from accessing that. And the lawyers may, once you're placed under oath, may ask you to verify and confirm that you have followed my instructions. Do each of you, and I'll ask this of parties and witnesses, do each of you understand the importance of ensuring that you're not communicating with each other and that you're not otherwise looking to educate yourself on what the testimony of the other witnesses has been? That's a fundamental rule of our trial. Do you understand that?
I do.
And the parties do have a right to remain present, but they are likewise not to be discussing their testimony. For example, I'm gathering that perhaps Mr. Payung and Reese Payung may be related. He stays in the room. He is not to be relaying to his relative what the other side just said, etc. So the lawyers, certainly the best part of what we have going on today is that each side has very capable counsel, very experienced. And as you've seen, and hopefully you appreciate it as much as I do, they've endeavored to be collaborative and professional with each other. And I think they've set a nice tone for all of us. So they will drive, they will ensure that the testimony and the evidence reaches me appropriately. So each of you sit back and just wait for them to ask you the questions. All right. So with that, I will do we prefer to have the waiting room, or do we prefer to just let people drop off and do you have good access to just text them and say, okay, hop back on, we're ready for you?
I can get in touch with Miss Marvel and Miss Downing. I just asked them both to, keep their phones close, and so that when their time comes that I can get in touch with them quickly and they can get back on the Zoom when they have to.
Okay,
Yes,
ladies, if you're okay with that, we'll let you go ahead and drop off. The nice thing is, compared to if we were live in the courthouse, you'd be stuck on a wooden bench in the hallway. This way, at least you can go about your business just as long as we can get you right back promptly, okay? All
Yes,
right,
ma'am.
we'll let you all drop off. And then, Mr. Blunt, for your part, you've got one or two folks that may be dropping off.
Only have Reese Payon that'll be dropping off, Your Honor.
Okay.
So Reese, you understand you're going to drop off and you're not going to watch the public version of the trial. Catherine will call you and give you a heads up when you're on deck, okay?
Yes, I understand.
Regina, can you just, are you signing off there, or?
Yeah, she's got to actually disconnect, because otherwise potentially she's.
Yeah, I'm leaving the Zoom call. Yes,
Okay,
ma'am.
thank you.
Yes, ma'am. You're welcome.
Okay, and now everybody who is in the courtroom is a party, or counsel or clerk or judge. Okay, all right. Other than invoking the rule, Mr. Blunt, anything else from a preliminary standpoint from defendant?
No, Your Honor, I think we're ready for opening statements.
Okay, and I know you're also counter plaintiff, but I'll shorthand it as Mr. Knight being plaintiff's counsel and Mr. Blunt being defendants. Okay, then Mr. Knight, if there's nothing else, I'll invite you to make an opening if you wish.
Yes, ma'am. Thank you. May it please the court. Asher Kanipe on behalf of CMR Construction & Roofing LLC, Sean Sheffer and Cheyenne Sheffer plaintiffs. Judge, on or about February 2nd of 2018, CMR Construction, Sean Sheffer and Cheyenne Sheffer entered into a residential lease agreement with Mark Payung, whereby they leased 1170 20th Avenue, Northeast Naples, Collier County, Florida, 34120 for purposes of residential use. The term of the written lease began on February 15th, 2018, and had ended on February 14th, 2019. Rent was monthly at the rate of $2,500 per month. There was a $2,500 security deposit. Additionally, among some other various fees, the contract required that, and I'm going to be referring generally to the plaintiffs as the Sheffers, but this is collectively all of the tenants. The Sheffers pay the last month's rent up front on or about January 31st, 2019. The Sheffers and Mr. Payung entered into an amendment of the original lease, which, among other things, increased the monthly rental rate by $100 and the amount that was being held by Mr. Payung for a security deposit by $100. So they paid $200 additional dollars for both the last month's rent or for the last month's rent, $100, and the $100 for the security deposit. By no later than February 14th of 2019, the evidence will show that the tenants were enjoying a month-to-month tenancy at the premises. On July 17th, 2020, after approximately 2 years and 5 months, the Sheffers sent written notice to Mr. Payung of their intention to terminate the tenancy and vacate the premises after July 31st of 2020. The evidence will show that Mr. Payung was under a misapprehension of the status of the agreement between the parties, and that he believed that the Sheffers were abandoning the leasehold while still under contract for additional months. The evidence will show that Mr. Payung reacted angrily to the Sheffers' lawful termination of the tenancy and threatened legal action against them. The evidence will also show that from the date they submitted the termination notice till July 27th of 2020, the Sheffers took efforts to clean and repair the residence in advance of the turnover. There was a walkthrough of the premises that was scheduled between the parties to take place on July 27th, 2020, as essentially a punch out between the parties for any damage claims that Mr. Payon wanted to make as to the residence to be resolved by the Sheffers prior to the end of the leasehold as they thought reasonable. On July 27th, 2020, agents of the Sheffers and Mr. Payon met at the premises to discuss the condition of the premises. While this was happening, there were third parties present conducting ongoing cleaning and repair efforts. The evidence will show that unfortunately, on July 27, 2020, Mr. Payon or his agents caused the locks on the premises to be changed, effectively excluding the tenants from possession and wrongfully evicting them. The evidence will show that the plaintiffs timely objected to this, and that but despite this, Mr. Payon acted spitefully in doing so, again, based upon his misapprehension that the Sheffers had abandoned the premises. On or about August 30th, 2020, Mr. Payon wrote a letter that was later sent to the Sheffers in the mail regarding the security deposit and the last month's rent, totaling $5,200, to inform them of his intention to keep said money for what he alleged were damages to the property caused by the tenants. On or about August 18th, 2020, the tenants sent a letter to Mr. Payon objecting to his retention of those monies and stated, amongst other things, that Mr. Payon had foreclosed them from making additional repairs and cleaning as a result of being locked out and wrongfully evicted. Plaintiffs are seeking return of the security deposit and last month's rent. After submission of the evidence, it will be clear to you that the only permissible verdict is in favor of the plaintiffs. Thank you.
Okay. And Mr. Blunt, do you wish to make an open, and do you wish to do it at this time?
Yeah, I do want to make an open, Your Honor. Revisionist history is the best term that I can think of to describe the plaintiff's actions in this case. I'm going to ask the court as we go through this matter to look very carefully at the dates when things occurred and the dates on communications between the parties, because it will reveal that the sequence of events as described by Mr. Knipe is simply not accurate. What the evidence is going to show, Your Honor, is, and up to the point where they're on a month-to-month tenancy, Mr. Knipe and I agree. Plaintiff and defendants agree. They're on a month-to-month tenancy due to an error by my client where he thought he had sent them a renewal. He thought he had gotten a signed renewal, but he didn't. And he's not going to contend today that he did. So they were on a month-to-month tenancy. Mr. Knipe just indicated that there was a notification on July 17th. That's not accurate. In fact, how they notified Mr. Payon, what the evidence will show, is that on July 7th, not the 17th, they notified Mr. Payon via text message that they wanted to talk to him. And that night they spoke to him by phone. Cheyenne Sheffer spoke to him by phone and told him her husband got a job in Oklahoma. They're leaving right away. They then sent additional text messages the night of July 7th and July 8th saying, we want the electricity out of our name ASAP. We want to know we're going to go turn over the keys to the CMR office. We're out of here. They called him and said, we're leaving. Mr. Payon then immediately arranged a walkthrough on July 8th. I think it's important for Your Honor to note that Mr. Knipe did not mention that. He did not mention a walkthrough on July 8th. Their initial walkthrough was on July 8th. We are going to show you photographs, Your Honor, that have already been admitted in evidence of the condition of the property on July 8th. Reese Payon visited the property on July 8th, took photographs of, quite frankly, the abhorrent condition of the property. And I want Your Honor to note that in these text messages, they repeatedly assured my client everything had been fixed, nothing was broken, everything was in great shape, don't worry about a thing. This examination on the 8th revealed that that was not the case. Reese then left and said, look, all of these things have to be fixed. Cheyenne informed, and I apologize, Your Honor, I should refer to her as Miss Sheffer. Miss Sheffer informed Reese that these things were going to be fixed. As Reese was taking photographs of the damage, holes in the wall, writing on the wall, damage to the carpet, damage to the cabinets, et cetera, et cetera. Ms. Sheffer was assuring Reese Payung, oh, that's going to get fixed. That's going to get fixed. That's going to get fixed. Reese left and said, we'll arrange for another walkthrough. I want Your Honor also to note that they then sent a notice of termination that was falsely dated July 7th, sometime after July 9th. That notice of termination specifically requests a move-out walkthrough the last week of the tenancy, the last week of July. When Reese is there for the walkthrough on July 8th, the evidence will show there was a moving truck out front. All of the things had been packed. The Sheffers were leaving. They then left. Reese Payung returned to the property sometime later between July 8th and July 22nd and looked in the windows and could see that nothing had been done. Nothing was going on. Nobody was there. I would note that the lease has a provision in it that if you leave the premises empty for more than half of the duration, you have technically half of the duration of any month, which would be 15 days, Your Honor, that the premises are presumed abandoned. So after the 22nd, the evidence is going to show that Mr. Payung notified them, I'm coming in on the 27th, last week of the tenancy, to go ahead and assess what's been repaired and what's not been repaired so we can move forward with getting this place ready to relent. They scheduled that walkthrough on the 27th. The evidence will show that CMR repeatedly amongst themselves and to Mr. Payung said everything was fixed, everything's great, everything's done. The only evidence you're going to see of any efforts on their part to clean up anything is one receipt from a company called On It, where they spent about 4 hours painting and cleaning up. And that was on the 25th and 26th. On the 27th, Reese arrives at the property again for the follow-up walkthrough. This is the final walkthrough, the turnover walkthrough. Mr. Payung will testify that he arranged for a locksmith the day before because this was the designated turnover by the parties. They showed up on the 27th. They walked in. The evidence will show that Miss Angela, and I apologize, Angela Downing, I believe is her last name. Angela Downing came from CMR to attend this inspection. I believe both Angela Downing and Reese Payung will testify that Angela Downing was shocked by the condition of the property, that it was still in horrible condition. We will show, Your Honor, a plethora of photographs taken by Angela Downing, showing the condition of the property on the 27th. Angela Downing then left. One would only assume that she then informed CMR, and I want Your Honor to note that CMR, Steve Soule of CMR, was not here. He didn't see what was going on. He was dependent on what he was being told by Mr. and Mrs. Sheffer or what he was being told by Miss Downing. So one would assume that she then contacted Mr. Soule and said, Shikey, this place is in terrible condition. It was not all taken care of like we thought. So then Mr. Soule begins with the revisionist history. He then begins sending emails saying, hey, wait, we have people coming in. We have people coming in. We were trying to do work. This is all after turnover, Your Honor, after turnover. So what the evidence is going to show is that there were two walkthroughs, one on July 8th. They assured him everything would get fixed. Another one set up for July 27th. July 27th is turnover. Locks are changed. Everything's done. And then it's, oh no, we were going to come in on the 28th and 29th. And the disingenuousness of the argument, Your Honor, is going to come out very clearly. And I want you to pay particular attention when we start talking about the screen repairs, because they will admit that there were many panels broken on the screen. You're going to see photographs of where they duct taped the screen back together, et cetera, et cetera. And they got an estimate from a screen company. The screen company didn't need to go in the house. Screen company wasn't locked out. There are no gates in this community. It's out in Golden Gate. Yet they still didn't send the screen company in to do the $1,800 worth of work that even they estimated needed to be done. So that's really what this is about. Mr. Soule's out in Texas, I believe, and he doesn't know what's going on except for what he's being told, and he wasn't being told the truth. So he thinks Mr. Payung was being unreasonable. But Mr. Payung knew the truth because he saw the photographs, he saw what was going on, and he knew that they had trashed his house. So that's what the evidence is going to show, Your Honor. And at the end, we're going to ask you to return a verdict in favor of our client for damages as set forth in exhibit number 24, which sets forth our damages, and most importantly, reserve or determine that our client is the prevailing party and entitled to attorney's fees. Because what we're also going to note, Your Honor, is although Mr. Knight referenced my client being litigious in nature, you will note that my client did not pick this fight. And he will testify regarding his intentions in that regard. And so the attorney's fees are really going to be a big issue here today. And we want to make sure that the court reserves as to the entitlement or as to the amount after determining that our client is entitled to attorney's fees. Thank you.
All right. And let me, because I've got the parties present here, I thank you both for the opening. And I had reviewed the pretrial statements as well, and everything tracks there. And so, Mr. Knipe, you all have sued for wrongful retention of security deposit, et cetera, and the countersuit is for the damages. And all of that is under Chapter 83, which would make, I believe, do we agree the fees go in both directions? In other words, if plaintiff wins, they would be getting their fees. If defendant wins, they would be getting theirs. I know I've enjoyed already working with both of you. I'm confident that you have thoroughly vetted that issue with your clients. Is that correct, gentlemen?
There is a reciprocal right to attorney's fees under the both this chapter and the contract, to the extent it remained in effect, and the applicable section under 57-105 for reciprocal nature of attorney's fees. So I don't think there's any dispute that should the court, judge, all of this is contingent upon, the case law regarding what is a prevailing party, and, we can get into that at a later date, but there is a reciprocal right to attorney's fees for the prevailing party. There's no dispute on plaintiff's part.
Okay. And I appreciate that. I think the main thing is I don't want to sneak up on anyone. With that, I know that human nature being what it is, the fight is pretty all-consuming. And I know that both counsel have encouraged thoughtful discussion with regard to any sort of middle ground or resolution that could be found here, and that has not been fruitful, and that's okay. I'm happy to sort this out. But if there's been a feature that I could note from many lawsuits of this nature, it's that the losing party ends up being shocked by the bill. This is a fight over about $5,000 initially, and it could easily go 10 times that by the time you're finished paying your lawyer on the other side. This is, a small war, and there's a big price tag with those. So I'm confident counsel has spoken to their clients about that, and that I'm not going to sneak up on anyone. But if there's a common refrain when I get to the fees hearing, it's, their fees are outrageous. I can't believe they spent all that money. And you go, well, but you wanted a war. You wanted to go all the way to the wall with that fight. You took it all the way through a full day trial. And so everybody goes in eyes wide open that unfortunately I can't settle the case. I can't make both sides a winner. I don't know exactly how the facts will shape up, and maybe there'll be some version of gray area, but generally speaking, only one side's going to get their fees paid, and it's a heavy hammer. But I'm confident both counsel have vetted that with their clients. The clients go in eyes wide open, knowing that this is not something that's going to only cost you a maximum of $5,000, that it's not necessarily just going to cost you what you've paid so far for your lawyer. And with that caveat, I'm prepared to start to hear the evidence. If along the way, there ends up being any interest or any discussion, I will note for both counsel that you're never going to hurt my feelings. I've had cases settle after I heard the whole evidence. It's okay. So if you want to take it out of my hands at any point, you may. But I am well rested and looking forward to hearing the presentation from both sides and ready to do that. So having heard the openings from both sides, we've got our preliminary matters out of the way. I think, Mr. Knipe, I can invite you to call your first witness.
Okay, plaintiffs would call Cheyenne Sheffer. So Cheyenne, if you could just unmute yourself, but you're on the video there. Can you hear me all right, Cheyenne?
I can, yes, sir.
And
Okay.
I'm going to get her sworn in. Madam Clerk, do you want to do the honors, or I can? Either way.
Well, since I'm here, Judge, I don't mind.
I will appreciate you carrying some of the load. Thank you.
Okay. If you can raise your right hand, please. Do you swear or affirm the testimony you shall give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Could you state your name, please?
Yes, it's Cheyenne Sheffer.
All right, and are you married?
I am.
And who are you married to?
My husband's name is Sean Sheffer.
All right, and what line of work is Sean Sheffer in?
He's a supervisor for CMR construction.
Okay. And what type of supervising does he do for CMR construction?
He's the punch-out supervisor. When the roofs have been fully installed and there requires any maintenance afterward, he runs the crew that goes out and does the final touches on everything.
Thank you. Did you and your family come to Collier County after Hurricane Irma for work?
Yes, we did.
Okay, and who did you come with?
My husband and our 3 small children.
Okay, and when you came down to Collier County, where were you living?
We found a house online for rent. It was the address is 1170 20th Avenue Northeast, Naples.
Okay, and is it a single family home?
Yes, it is.
Okay, and I think you just said you were renting that property.
Yes, sir.
Judge, if I may just take over the screen share at this point.
Please.
Okay. All right. And I know these things have already been admitted into evidence, Judge, but just for, belt and suspender, I'm just going to be putting up on the screen here what has been previously entered into evidence as Plaintiff's Exhibit 1. Ma'am, you've had an opportunity to review these documents prior to today. Is this document the residential lease agreement that existed between you and the landlord, Mr. Payon?
Yes, it is.
Okay, I'll just stop that right now so we don't have to look at that anymore. When you moved in, what was the rent that you were being charged by Mr. Payon?
It was $2,500 a month.
Okay, and did you have to pay the last month's rent in advance?
Yes, we did.
Okay, and so that was another $2,500?
Yes, it was.
Okay, yeah, and this just for, I know this is somewhat awkward, but when you're answering questions, you have to give a verbal response. So I apologize for that, okay?
Sorry.
All right,
Yes.
Thank you. Did you have to pay a security deposit?
Yes, we did.
And how much was that initially?
That too was $2,500.
Okay. Do you remember when you moved in?
Yes, it was February of 2018. It was the 15th, I think.
Okay. Do you remember what time you arrived?
Yes, it was very late. It was almost midnight.
Was anyone there to greet you?
No, sir.
Okay, but you were able to get into the residence without any issue?
Yes, I had spoke with Mr. Payong's realtor, Kirby Richard from Cision Realty, on the phone. He said that because it was going to be that late, he was not going to be able to make it. So he emailed me the lockbox code to get into the house.
Okay, so you were able to get in. It was late, but you were able to get in because there was a key in a lockbox.
Yes, sir.
Do you remember taking a video when you arrived at the residence?
Yes, I did.
Okay, why did you take that video?
It's the first time we moved away from home, and I was very excited. So I made the video for my mom so she could share the moment with me.
Okay, fair enough. All right, bear with me a second here while I deal with Zoom here. Okay, and all right, there. Okay, what I'm putting up on the screen here is what has been previously marked as and entered into evidence as plaintiff's exhibit number 18. This is and what I will represent to you is that this is a screenshot from the video that you were taking. Do you remember taking this video?
Yes, I do.
Okay, what are we looking at here?
That is a screenshot of the master bathroom closet.
And why is this photo interesting for our purposes here today?
Well, I stopped the video there and took a photo, took a screenshot of that because you can see the date along with the stains on the carpet.
Okay. So when you moved in, the carpet wasn't brand new?
No, not at all. They were heavily trafficked, and there were stains already on the floor in the closet.
When you moved in, did you have an initial walkthrough with a representative of Mr. Payon to go over the condition of the property?
No, we did not.
Okay, and was that something that was contemplated at any time?
No, nobody ever said anything about meeting or going through it, or Mr. Payon never asked me to, point out anything. We spoke about some things over the phone over the first few months, but no.
Okay, and was this the first time that you had ever rented at any property?
Yes, yeah. Other than homes that my family had owned.
Okay.
In Pennsylvania. So yes.
All right. Do you remember making a damage list for items that you had observed after you had moved into the property?
I do. I do. I wrote some few things down on a piece of paper over the first couple weeks that we were there.
All right. And bear with me a second here while I attempt to. What I'm putting up on the screen now is, again, an exhibit that has been entered into evidence. This is plaintiff's exhibit number 16. Can you tell the court what we're looking at here?
Yes, that is the list that I made between February 16th and on the bottom I dated where I signed, I dated it, which is February 25th of that month.
Okay, so
Can I just interrupt real quickly, Mr. Knipe? And I don't think you need me to read this now, but as you screen share, anything that you I've got a pretty good size screen, but it's only a fraction of a fraction of a fraction of a screen when you do the screen share. So anything that you're actually going to need any of us to be able to read, this is at 14.2% zoom. If you could try to puff that up so that the gray on the left and the right disappear there, perfect. So if I need to be able to see it, fine. If I don't want to trouble you with it, but that's much better for me. Thank you.
okay, and just I was going to walk through these with you anyway, so.
That's fine. I don't need to slow you down on anything you don't want me to scrutinize. But when we get to that point, I just want to make sure that you do your best to maximize it on your screen.
Okay.
Thank you.
Yes.
Carry on.
Okay, thank you. So Ms. Sheffer, let's like the judge has invited us to do, let's walk through these items on this list, okay?
Sure.
What this first item on here, it says mailbox vandalized, broke off post. Tell us what that was.
Well, that looks, it looks to me like somebody had driven by and hit the mailbox with a baseball bat or something. I had told Mr. Pang about it. You know, I don't remember the exact date, but we just spoke over the phone after we were there a couple weeks, and I told him it took a few months, but his mother eventually dropped one off and we installed it for them.
Now, the next one here, it says cracks in the grout by bathroom, in bathrooms, open pairing, both closed pairing, by family room, glass sliding doors, all grout stained brownish. Tell me what that means.
Yes, that just means that there was tile, about an 18 by 18 inch square tile throughout the almost the entire home with the exception of the bedrooms, and all of the grout in between looks like it was supposed to be like a white or a tan color. It was very dirty. There was like a residue or like a buildup along the walls that I had to scrub off. I'm not sure exactly what it was. When you scrubbed it with a scouring pad, it did come off, but I wasn't able to get the grout back to the original lighter color. And the that just
okay. So
yeah, that's pretty much it.
Okay,
Yeah.
the next one that
It was back along the walls is what that means.
okay, and I understand that some of these are probably self-explanatory, but due to the nature of
if you want, I can read them if you want me to just go through
Go
a little
ahead.
faster. Okay. So there were some minor dents in the refrigerator, nothing major, just some dings, probably no deeper than, I don't know, like a quarter inch or so, 3 or 4 of them. The ice maker and the water dispenser on the refrigerator on the freezer side did not work. The drain plug in the guest bathroom was simply missing. Wasn't a big deal. We bought one. I didn't know if there were supposed to be blinds on the family room glass or the arch window, but there was not. So I wanted to put that on there. There were missing receptacle covers in the bedrooms. There was a big long wire sticking out of each of the bedrooms. I assume it was supposed to be for a television hookup, but it was just kind of flopping around in there about 8-10 feet long. And in my daughter's room, we had to shove it back into the wall. Some light switch covers were cracked. The garage door opener did not work. It was broke. The back was broke off. It was just in pieces. But we didn't park in the garage. We just parked our motorcycle in there. So we didn't use it. The security system wasn't plugged in. The cord was just kind of hanging off of there in the master bedroom closet. We never used it. We never even plugged it in. The door handle on my son's room, the one on when you walk in, the one on the right side, would not stick, and it whenever it wouldn't release. So we replaced both of the door handles on all 3 of the doors there, both bedrooms and the bathroom, so they all matched and they all worked. We had to replace the AC filter. It was really dirty. It seems to get clogged up pretty quickly there, even when you change it every month, but it was pretty bad. We had to change that when we first got there. The plastic coating on the cabinets, it was cracking and peeling, and there was some broken ridge tiles on the roof and a few other tiles on there. My husband, being a roofer, saw that right away. Every time he would leave for work, he saw them. Some cracks around the pool, the concrete in the pool and the patio areas. There were ant infestations in the bathrooms and in the master bedrooms. Also in the kitchen, but I didn't write that down. Pest control said it was supposed to be taken care of by the landlord on the lease, but when I asked him about it, he refused to take care of that. And that was everything that I wrote down at the time.
Okay. Now, I notice on here that you didn't write anything about any stains on the carpets. Was this a comprehensive list?
No, it was not. I'm not in construction. I don't, inspect homes for a living, and I didn't know that I had to go through the house with a fine-tooth comb and write down, every single thing that had a minor flaw or even major. Nothing that was wrong outside was wrote on there. I didn't know that I had to do that.
Okay, but you did bring up some of these items with Mr. Payong over the phone at various times?
We did speak about a few of those things, maybe not all of them, but
Okay.
At one point, I know we spoke about the cracks in the tile and the grout. He asked me to send him photos of it, and I did, and he never responded about them, so I assumed that it wasn't a big deal. We talked about the security system. I told him that I just wouldn't use it. Like I said about the pest control, we spoke about that a couple times, and his response was, well, this is Southwest Florida. So, and then probably the other things too. I don't remember.
I didn't mean to cut you off. I keep going. If there is anything else you want to say.
I know we spoke about a couple of the other things, but I don't have any recorded phone calls or I always thought that it was better to, when you had an issue, that it was better to talk to somebody rather than text or email. I thought it was impersonal. So I called him. So. Okay.
But like on that list that I just turned off there, you did also make note of the fact that the plastic hot coating for the cabinetry was cracking and peeling off. That was something that's something you observed when you moved in initially?
Yes, it was.
And all right. Thank you. All right. Did Mr. Payong require you to enter into a lease agreement?
Yes.
And what did the lease agreement increase the monthly rent that was due?
Yes, the addendum. Yes, it did. It increased it to $2,600 a month instead of $2,500.
And did it increase the security deposit amount to be held by Mr. Payong?
Yes, it did. It added $200, $100 for the last month and $100 for the security deposit.
Okay, so that it increased the total amount of money that he was holding by $200.
Correct.
Okay. And did you when did you decide to move out of the house?
My husband was offered another position in Oklahoma in July of 2020.
Okay, and is that where you're residing currently?
Yes, it is.
Okay, where are you? What's the name of your town? The town you're living in now?
It's Pittsburgh, Oklahoma.
Okay, I'll have to look that up on the map. I'm not familiar with Pittsburgh, Oklahoma. So, bear with me a second here. After your husband was given another job or a different job in a different location, did you advise Mr. Payong that you were going to be moving out?
Yes, I did.
Okay, and did you tell Mr. Payong that you were going to be abandoning the premises?
No, I did not.
Did you tell him that it would be okay for him to take possession back of the premises prior to the end of the leasehold that you had paid through?
No, I did not.
Did you intend to clean the residence before you moved out prior to turnover to Mr. Payong?
Yes.
Okay. Before you moved out, did you take any efforts personally to clean the premises?
Yes.
Okay.
Yes, I did.
Tell the court what you did.
So we took drywall spackeling and we fixed every single ding or dent or scratch that was on any of the walls, whether we made it or not. did normal cleaning. We wiped out all of the cabinets, cleaned toilets, bathtubs, floors. My husband pressure washed the entire house. He, did the porch, all the sides, the patio, around the pool. And I think that was about all that I personally did.
Okay. Did you take any efforts to try to clean the carpet?
Yeah, I did not, but I had put that on the list for the contractor that we hired to try to take care of that. Throughout the time that we were there, because the carpets were so heavily trafficked and they were old, and you could tell that they just weren't brand new, I cleaned any spills that we had. I have 2 small kids, so anytime that their sippy cup leaked, or they came in with dirt on them, or anything that had got spilled in their bedrooms, I did clean with a diluted bleach water. The carpets were a really light color. It did bleach the carpets, and there were multiple spots on them. But my intention was to just put at the end of our lease, when my kids were a little bit older and stopped drinking out of sippy cups and stopped spilling things and walking around with things that could cause any stains on the carpets or the floors, we were going to put a bleach in the carpet scrubber, run it over the whole thing, and lighten the whole thing. They needed scrubbed anyways, and in my experience, my family owns cabins in Pennsylvania, and we have tan, lighter carpets in a couple of the rooms, and it works really well. Our contractor was going to do everything she could to rectify that and make everything nicer than it was whenever we got there.
All right. What was Mr. Payung's reaction to you when you told him that you were going to be terminating the lease?
He was mad. I told him that I had something to tell him, that I needed to speak to him, but I would like to do it over the phone, so I thought that would be more respectful. And when I told him that my husband had been offered this, amazing job opportunity, he got really mad, and he hung up on me, and he texted me this number, $15,600, to get out of our lease, that we owed him that much. And well, I'm sure you'll bring up the text messages from there.
Yes, and I'm trying to. I just did something on Adobe here, and I'm trying to figure out what there we go. All right, bear with me a second. What I'm sharing on the screen here is what's been admitted as plaintiff's exhibit number 13, and for Judge Martin's, I'm going to blow this up for you here. Is this the text message that you're referring to, Ms. Shepard?
Yes, it is.
Okay, so let's. So you reached out to Mr. Payung to tell him that you wanted to talk to him about the fact that you were going to be terminating the lease, correct?
That's correct.
And so you called him up on the phone, correct?
Yes, I did.
All right. And then, and it says here, all right, I will talk to you this evening. Don't worry, nothing is broke or needs fixed, LOL. And that was about 1:50 p.m. So what am I to interpret this as sometime between 1:50 p.m. and 8:32 p.m. on the day that you had a conversation with Mr. Pam, explaining to him that you were going to be terminating the lease?
Yes, that is correct.
Okay, and after your telephone conversation with him, he responded to you and said, Cheyenne, the lease amendment was signed 2/1/19 and renewed 2/1/20 automatically. You, your husband, co-tenants, and the roofing company tenant will be held in full force of the lease until end of February 1st, 2021. Is that consistent with what he was telling you on the phone?
Yes, it was.
Okay, and when it says down here $15,600 owed to get out of the lease, what was he telling you in that regard over the phone?
That was the amount of the rent, that the rent would be from after July 2020 to February of 2021.
Okay, and he said that he would be having an attorney contacting the roofing company tomorrow?
Yes.
So he threatened litigation with you about what he thought his understanding was with regard to your ongoing obligations with regard to rental payments.
Yes, immediate. Yeah, pretty much immediately. I stopped responding for a while after that.
Okay. All right. Bear with me a second here. Um, when did you move out from the premises?
We physically left on July 12th of 2020 and gave the keys and everything to our CMR representatives who were, co-tenants on the lease.
Does CMR have an office in Collier County?
They do. It was only about maybe 20 minutes from our house.
Okay. After you physically moved out of the premises, did you take any further actions to either repair or clean the residence?
Yes, we did.
Okay, what did you do?
We hired Regina Marvel at On It Cleaning and Repair Company to do the rest of the things that we didn't have time to. We asked her and her crew to finish sanding all the areas that we had spackled and paint the entire house. We asked her to finish cleaning, wipe the ceiling fans and anything else that I might have forgotten. She went around and cleaned the baseboards. She swept and mopped again. She was going to try to, rectify the bleach stains on the carpets. She wasn't sure if the bleach scrubber was going to work. So she, we had talked about possibly dyeing the spots to match the rest of them. But she's the cleaning, that's her business. So I just, told her to use her professional opinion, whatever was going to work the best there. And she was also going to clean the windowsills because after you pressure wash, the outside, they get, kind of stuck. All that crud gets stuck in there. So she was going to go through and clean the windows also. I asked her to take a look at the screen also. There were some holes in it. We did not damage that screen. There were holes in it. I didn't notice it until we'd been using the pool, for a while, and there seemed to be a lot of bugs getting in. There was a lot of those little gnats and stuff like that, like there is in Florida. So I went around and I found a couple holes, and yes, I duct taped them because, I didn't feel it was my responsibility to fix it or pay to fix it. But then at the end of the lease, when it was clear that, Mr. Payung was going to try to get, all that money from us, I decided to try to go a little above and beyond. And we did get an estimate for the screen repair. We weren't sure we were going to do it, but we were contemplating it. But after we got locked out, it was clear that it didn't really matter what we did, that it wasn't going to be enough. So we just kind of pulled the plug on the repairs after we got locked out.
Was there a damage to the pool cage structure that you observed?
Yeah, there was a dent, small dent in the corner on one of the corner posts.
Is that something that you or your family caused?
No, we did not.
Okay. Was that pre-existing you moving into the home?
Yes, sir.
Okay. Did you receive an invoice from Regina Marvel for the work that she did?
Yes, we did.
Okay, so is it your understanding then that at least some of the work that you had committed them to perform in terms of repair and cleaning at the residence was actually completed?
Yes, the only thing she really got done was some light cleaning and the painting. You know, they were going to go back in after everything was all dry and, you know, make and finish the last couple of things that they didn't get a chance to do.
And if I may here, just a moment. What I'm putting up on the screen here, right, is what's been previously admitted as, come on, Ash, what are you doing here? Like exhibit number 79. Is this the invoice that you received from Miss Marvel?
Yes, that was the invoice for just the painting, just the sanding and the painting.
Okay. All right. All right. And if I may here, just bear with me again, it's just a second. What I'm putting up on the screen now is what's been previously admitted as plaintiff's exhibit number 78. Is this the screen repair proposal that you received?
Yes, it is.
Okay, now I was looking at this. It appears that there were two separate bid estimates provided to you. One was for a general rescreen, and then there was a panel repair. One for $1,850 and another for $475. Were those two separate options that were presented to you by this screening company?
Yes, it was.
Okay, but you did not engage them formally to complete these repairs?
No, we didn't. Like I said, after everything that transpired between Mr. Payong and you know, my husband and I and CMR, we just figured that there was no point. You know, I know it is on the outside, as Mr. Blunt pointed out, but I mean, you know, he sent us, you know, multiple different lists of all of these things that he said that we damaged. You know, he said every window was damaged, every faucet was broken, you know, that there were stains on the garage floor that we caused, and you know, all of these things that were just so far above and beyond anything that you know, I feel like we were responsible for. I mean, that it really wouldn't have mattered, you know, what we did. He wanted enough money till 2021 of February. So it was clear where this was all going.
Sure. Was the house in pristine condition when you moved in?
No, it was not.
All right. You mentioned the garage floor. There was a stain on the garage floor that Mr. Pang asked for you to remedy?
Yeah, it wasn't really a stain. It was it was, I mean, I guess it would be considered a stain. The garage floor is concrete, and there was a couple areas that were a different color. They were a little bit darker. I don't know what they were from. They were there, you know, they were there when we got there, but it was a, you know, it was a garage floor. I didn't see it. When I saw it, I didn't, you know, picture it as damaged at all. There were no chips or cracks or, nothing wrong with it. It was just a different color concrete.
Okay. Well, and I think you also mentioned a caulking inside some of the bathrooms. Was there were you going to be taking any effort to repair or remediate any of the bathroom caulking?
Before it was clear that it didn't matter what we did, yes, I was going to have Regina Marvel with On It Cleaning and Repair remove the caulking. It was one of the things that they had listed on the walkthrough with Mary Ann Payung, who is Mark Payung's mother. She had listed on their punch out list that there was some like mildew, mold or mildew. And it wasn't like it was growing mold. It was, again, it's Southwest Florida. When you have 3 kids, taking baths every day and the bathroom retains a little moisture, the white caulking around the bathtub and around the sink, over the time we were there and however old it was before we got there, had started to tarnish and get a little discolored. So again, to try to leave the house nicer than what we got it in, I was going to have her reseal those.
Okay. And again, just for the court's edification, did you ever tell Mr. Payung that he could take over the property before July 31st of 2020?
No, we did not. We did not agree to a final walkthrough or turnover on the 27th either. That meeting was specifically to complete a list of repairs that they wanted us to do. So we had another 4 days to finish it so we could end this on good terms.
Okay. I don't have any further questions of this witness.
Okay, Mr. Blunt, cross-examination?
Yes, Your Honor. Good morning, Ms. Sheffer. I'm
Morning.
Steve Blunt. We haven't met yet. I'm going to ask you a few questions, and if you don't understand any of my questions, please let me know. But this is my opportunity, because we didn't take a deposition, to learn how this all went down, because I obviously didn't live this. Let me ask you first, how did you find this house? Did you look for an ad? I mean, did you view it on Zillow or anything?
I did, yes. And I'm sorry, I don't remember if it was Zillow or Trulia that I initially saw it on, but I believe Zillow is the one that I contacted the realtor through.
Okay. And did you look at pictures of the house on Zillow?
Yes, I did.
Okay. I am going to show you what we have marked as Defendant's Exhibit 2. Is this a picture of the house?
Yes, it is.
Yeah, I'm going to kind of scroll through these pictures for you. Does this appear to be the pictures you saw on Zillow?
Yes. Yes, they look like it. Yep.
Right. So for instance, there's no blind in the dining room. I mean, you knew that before you moved in, right?
On that one. Yep, that's correct.
And would you say, did these pictures accurately depict the condition of the property when you moved in February of 2018?
With the exception of some close-ups on some of the items that, we noticed afterwards. Yeah.
Okay. Would you agree with me? The property is pretty clean?
Well, from what you can see in the pictures, yes, I do.
Blinds look in order, not broken or anything?
Mm-hmm. Yes, sir.
Okay. And when you got there, you didn't say, hey, wait, this isn't what I saw in those pictures. I mean, you got what you thought you were getting when you showed up there, right?
Yes.
Okay. Let me now show you what we have marked, or what we have admitted in evidence as Defendant's Exhibit 3. Okay. Is this your email, CheyenneSheffer@gmail.com?
Yes, it is.
Okay. Do you recognize this email as having been an email you sent in June of 2018?
Yes, I do.
Okay. And is this the email that you talked about where you sent pictures of the crack, where you talked about the cracked grout?
That was one sent, yeah, after we spoke on the phone about other things, yeah.
Right. And you told him you were not concerned about the dispenser on the fridge, right?
Correct.
Okay. You said the garage door opener didn't work, right?
Correct.
Okay. And you told him in June of 2018, and you sent this email to Mr. Pang, we absolutely love the house. Isn't that right?
That's true. We did.
And I want to go back to your Exhibit 13 for a minute. As Mr. Knipe asked you some questions about hold on one second, it may not have been 13. That's the trick about this electronic stuff. You gotta bounce around to make sure. I'm actually gonna go to Exhibit 16, okay? This is that set of notes you said you made in February.
Yes.
This note you made in February, you don't have, well, let me pause for a minute. Are you aware that Mr. Knight produced on your behalf in response to discovery over 1,500 pages of documents in this case?
No, I was not.
Okay.
I know I.
Were you asked to collect all your emails and communications with everybody relating to this case?
Yes,
Okay, and did you collect them all and give them to Mr. Knight?
I did.
Okay, and among those emails that you texted, there's no emails or text messages indicating that you ever sent this list to Mr. Payong, right?
No. I suppose
Okay, and in fact, assuming this really was written in February of 2018, many of the things listed on this are not mentioned on defendant's Exhibit 3 in the email you sent him in June. Isn't that right?
No, that was in response.
Can you tell me, is there anything on Exhibit 3 here?
That he asked me to send pictures of the cracked
On
grout.
Exhibit, all right, but on Exhibit 3, did you complain about cabinets?
No, I did not bring up cabinets.
So you would agree with me that those complaints that you wrote down in February were not all incorporated into Defendant's Exhibit 3, which you communicated to him in June. In fact, in June, you told him you were very happy with the house, you loved it, right?
That's true.
Okay. So, and let me show you real quick. Gotta pop out of that. And this is kind of just a technical thing. I'm going to show you exhibit number 4. You recall Mr. Payong advising you and CMR of a change in address for him in October of 2018?
I don't believe I'm copied on that email.
Okay, but do you recall that he changed the address in October of 2018? He informed you and CMR of a change in the address.
No.
Okay.
No, we didn't communicate personally. I didn't know he moved.
Who sent the rent checks?
CMR representative.
Okay. You know who Carrie Rowland is?
I know of her. I don't know her personally.
All right. What do you know of her? Does she work for CMR?
Yes, she does.
Okay. Does she send out the checks?
Yes.
Okay.
Yes.
1 second. I want to make sure we nail down the date on this. This is Plaintiff's Exhibit 3. You testified that you called him, and I'm going to go a little higher in this text message where it says the blue is you talking and the red is Mr. Payung responding, correct?
Yes.
But he told you to call him between 6 and 8:30. And you assured him that there was nothing in the property that was broke or needs fixed. Isn't that right?
Nothing that we weren't in the process of already fixing.
Well, but you didn't tell him that. You didn't tell him there are things that we're fixing, but you told him nothing is broke or needs fixed, right?
That is what I said, yes.
And Mr. Knipe asked you about Exhibit 78. This was that screen repair estimate. Am I to understand your testimony? And I just want to make sure I understand what you testified to. You would have paid the screen company to fix it, but for you deciding that Mr. Payung was just being unreasonable, it wouldn't matter what you did. Is that right?
We were thinking about it. It was something that we may have been open to. It was honestly, if it was just to see how much it was, trying to be nice, but it was a little on the expensive end. So, since we didn't cause it, we also decided not to follow through with it.
Right. But I mean, in this estimate, they tell you that there's 8 panels broken. Is it your testimony that all those 8 panels were broken before you moved in?
I don't know of 8 panels that are broken.
Well, do you think that these guys at A Screen Repair were wrong?
No, they're the professionals. If there was something structurally wrong with it, it was, I did not know.
You know how old the screens were at this property?
No, I did not. I didn't ask.
We had a kind of a big storm in September of 17 called Hurricane Irma, right? I mean, that's why you moved here, right?
Yes.
I think maybe that a lot of people got their screens replaced after Irma.
Objection, speculation.
Withdrawn, Your Honor.
I have to remind myself to unmute. I would sustain that. It's been withdrawn.
All right. Now, on the 7th, when you had this phone conversation, had you sent a formal notice of termination of the lease on that day?
Not on the 7th, no.
When did you send a formal notice of termination?
I believe it went out on the 12th, but I'm not 100% sure. That was sent through the CMR office.
All right. Did you approve the form of the notice of termination before it was sent?
Approve the form? What do you mean?
Yeah. Did you look at it? Did you see it before it went out?
The one stating that we were was our intent to terminate the lease? Is that?
Well, let's be very specific. Defendant's Exhibit 6. Is this the notice of termination that you understand went out?
Yes.
Did you review this before it went out?
I was copied on the email, yes.
Okay. And so you're aware that whoever wrote this, it doesn't have a signature, but it purports to be from your husband, Sean Sheffer. Do you know if your husband actually wrote this?
It was written by our co-tenant,
Who?
CMR.
Who at CMR? If you don't know, ma'am, if you don't know, that's an appropriate answer.
Okay. I'm not sure who actually worded it.
Okay. But you saw it before it went out, and it says, I'd like to schedule a move out walkthrough in the week prior to my move. Isn't that right?
Yeah. Yes, sir.
And it asks for only a $5,000 security deposit, even though your testimony is that there were 5,200.
Well, that is what it says. Yeah.
Okay. When you reviewed it before it went out, did you say, hey guys, correct the date because it's not going out on July 7th? That's not accurate.
Objection, misstates testimony.
Sustained. I'm taking careful notes.
Okay. And you say you think this went out on July 12th, is that right?
I believe so. I'm not sure exactly what day it went out.
All right. And this notice says the premises are in good condition. Were the premises in good condition on the 12th?
No. Well,
thank you very much.
That are good condition.
You've answered the question, ma'am. There's no question pending of you right now.
Okay.
Oh, let me ask you one more question about that notice of termination. Never mind. You said you didn't know about the change of address. Never mind. So let's show you what's been entered in evidence as Defense Exhibit 7. And I'll zoom in here a little bit for you. This is on July 8th at 1:17 a.m. And I want to make sure that I understand. On July 8th at 1:17 a.m., where physically were you?
I'm sorry, what date was it?
July 8th, 2020 at 1:17 a.m.
I was at the residence.
Okay, in Naples, Florida.
Yes.
Okay, so that time stamp would reflect an Eastern Standard Time timestamp.
Yes.
Okay, your phone time is accurate. You don't alter it so that it reads some other time, right?
No, I don't.
Okay. So did you send this text?
Could you put it on the screen for her?
Oh, I'm sorry. I do that when I do mediations too, Asher. Or Mr. Knight. I'm sorry.
That's fine.
I apologize. So I'm going to zoom in here. This is the timestamp on this text message. And again, this is Defense Exhibit 7.
Yes, I sent that text message.
Okay. And this is after Mr. Payung threatened you that you owed through the term of the lease, and you asked for a copy of the lease that he claims to have had, right?
Yes, I did.
Okay. And you asked him for move-out procedures, right?
Yes, I did.
Did he give you move-out procedures?
He made a couple of requests.
Yeah, well, he told you he was going to send Reese Payung down to inspect the property right away, right?
Yes.
Okay. And then he told you he'd want to inspect it again after you made the repairs, right?
I don't know that he ever said that, but
Okay. He asked you not to give the keys to anybody else, right?
That was something he said, yes.
Okay. And you told him, you told him in his text about the electric bill, and you asked if you should turn it off ASAP. If you intended to continue to work in the property for 24 more days, why would you want to turn the electricity off?
The term ASAP there was referring to the end of the lease. We did not turn, I contacted Florida Power and Light and asked them to keep it on until August 1st, which they did.
Right, you told him the keys will be left at CMR's main office, right?
We gave them to Angela Downing.
And you told him that he could retrieve them. right? Told him he could come get his keys.
At the end of the lease, yes. He
Well,
could.
no, it doesn't say at the end of the lease, does it, ma'am?
I suppose I left that part out. I thought it was implied.
Okay. And you also told him, and again, this is at 1 o'clock in the morning on July 8th, correct? So at 1 o'clock in the morning on July 8th, so the night of July 7th, you told him, we have fixed, past tense, any dings or scratches we may have put on the walls. Isn't that right?
At that time, there was drywall spackling on every single little imperfection.
All right. As a matter of fact, you told him there was no damage to the property as of July 8th at 1:17 a.m.
There would be no damage to the property when we gave it back to him.
Not what you said, though, is it, ma'am? You said there was no damage. I mean, he's reading this and you're telling him there's no damage, correct?
I suppose he could interpret it that way, yes.
Yeah. Okay.